Hello, and welcome back to the Hearsay podcast. This is episode 2 of our Human Rights series. I'm Sarah Dallin, joined by Stephen Hodgson, Divya Chawla, and Robert Balak. And today we'll be continuing our conversations with Professor Jean Munn and Chief Michael Gottheil. In the spirit of reconciliation, we would like to acknowledge that Hearsay is recorded on Treaty 7 territory. We acknowledge that Treaty 7 territory is the traditional and ancestral territory of the Blackfoot Confederacy, consisting of the Kainai, the Piikani, and Siksika, as well as the Tsuut'ina Nation and the Stoney Nakoda First Nation. We acknowledge that this territory is home to the Métis Nation of Alberta Region 3 within the historic Northwest Métis homeland. We acknowledge the many First Nations, Métis, and Inuit who have lived in and have cared for these lands for generations. We are grateful for the traditional knowledge keepers and elders who are still with us today and for those who have gone before us. We make this acknowledgement as an act of gratitude for those whose territory we reside on or are visiting. Jean Munn is a University of Calgary alumna, having completed both her undergraduate and law degree here at the university before being called to the Alberta Bar in 1989. Jean served as a member of the Alberta Human Rights Commission from 2015 to 2021 and continues to hear matters that were assigned to her during this term. Jean has extensive experience in all facets of immigration and employment law. After graduating from law school and articling with the Alberta Court of Appeal, Jean set up her own practice in association with other lawyers where she practiced criminal, family, immigration, and employment law, as well as labor arbitration. Ms. Munn was a partner with the Calgary law firm Carson & Partners until the end of 2020 and remains with the firm to support clients and junior lawyers. Outside of her legal practice, Jean has also worked as a sessional lecturer in the University of Calgary's Faculty of Law, where she currently teaches human rights law. She has also worked as an instructor at Bow Valley College, a guest lecturer at Calgary Legal Guidance, and has written extensively in the area of citizenship and immigration law for both Carswell and Calgary Legal Guidance. Jean is actively involved with Calgary Legal Guidance, volunteering since 1993 and serving on the board from 2011 to 15. She was awarded the Alan D. Hunter Award for Excellence in Volunteerism from Calgary Legal Guidance and is also the recipient of the Queen Elizabeth II Diamond Jubilee Medal, recognizing outstanding and exemplary contributions to society. In 2021, she was awarded the Distinguished Service Award from the Law Society of Alberta. Michael Gottheil is the Chief of Commission and Tribunals of the Alberta Human Rights Commission, a role he assumed in August 2018. Mr. Gottheil brings many years of leadership experience in the administrative justice sector, having previously served as Chair of the Human Rights Tribunal of Ontario and Executive Chair of both the Environment and Land Tribunals and the Social Justice Tribunals of Ontario. Since commencing his role at the Commission, Mr. Gottheil has focused on improving meaningful access to human rights enforcement in Alberta by reducing the historic delays and backlogs in complaint resolutions. At the same time, he is driving the Commission to be more proactive, build capacity to address systematic discrimination, and to be a key partner in a diverse, inclusive, and just Alberta. Mr. Gottheil has written and presented widely on justice reform, including the importance of tribunal independence and recruitment practices that value substantial knowledge, diversity, and cultural awareness. He has driven collaborative initiatives which understand the critical role community organizations play in making justice accessible and meaningful for those who need it most. As a person with a disability, Mr. Gottheil is always open to sharing his experiences and to be inquisitive about others' differences, challenges, and insights. He is a firm believer that by listening and hearing diverse perspectives, we all grow stronger, individually and as a community.
In terms of granting a remedy, and maybe I can ask Jean this real quick. We saw recently, again in the criminal context, that the Supreme Court allowed sentencing guidelines in the criminal context again. Are there any kind of guidelines for the tribunal when rewarding a remedy? Is that guided by any kind of instructions from up above? How does that typically function? I know because it would probably change over time because of inflation and stuff, but when you're thinking of awarding a remedy, is there some kind of, like I say, a guideline?
Not formally. So as Chief Gottheil mentioned, the Alberta Human Rights Commission can award special general damages. And these are damages for injury to dignity, pain and suffering. The case in Alberta for laying out factors to be taken into account is the Walsh and Mobile Oil case. And so the courts have laid out factors that tribunal members can take into account in deciding where that amount of money should be. So historically, general damages were very low. Right now, if there's been a significant impact on the complainant, and if the respondent's behavior was not accidental, that is, if it was reckless or intentional, we can expect to see awards of general damages in the $25,000 to $30,000 range. Recently, in a Court of Queen's Bench decision, it was an appeal of a case called, at the appellate level, it's Sunshine and Bowenish. Justice Devlin, when dealing with a general damages award of $25,000, basically said, well, he did say, anything less than that $25,000 would have made the violation meaningless and would have made the human rights meaningless. So with that recent decision, I think that you will see general damage awards where there's been a significant impact on the complainant and where the behavior wasn't accidental or innocent. You'll see damage awards start to climb from 25,000 upwards.
And just before letting Robert ask his question, I'm sorry, Ron. Robert, I just had to ask this real quickly for our wider audience. Now, I know that within 1 year they must bring the claim to the commission. Can the commission consider time beyond this in calculating remedy? Like time prior to the 1 year, can they consider if there'd been ongoing discrimination in the workplace and then they finally were fed up, and within that 1 year, beyond that, can they consider that for remedy purposes?
Well, certainly for special damages. So general damages are pain and suffering. Special damages would include all the usual things like lost wages, lost income, expenses, that sort of thing. A human rights tribunal in Alberta cannot award lost income for a period greater than 2 years preceding the date of the complaint. But it can be, they can award lost income into the future, and it's not limited by common law notions of wrongful dismissal, for example, the common law notion of reasonable notice.
Yeah, I was just one other thing on the damages. So a number of the statutes across Canada still have limits on the amount of general damages that can be awarded. So for example, the federal statute, the limit is $20,000 and $40,000 if it was reckless and willful. In Ontario, it used to be, I think, $10,000, but in 2008, when the reforms came in, they lifted that cap. So traditionally, the legislation in Canada has had a limit on general damages that seems to be lifted now, but there still is a lot of debate within human rights circles, and some excellent work done by Bruce Ryder, who's a professor at Osgoode Law School, and you mentioned, inflation, and one of his findings from a study was that, general damages have actually dropped over time, in the sense that when damages are adjusted for inflation, the general award, just based on precedent and so forth, has not kept pace with inflation. And so there's a lot of debate, I think, in Canada, I think healthy debate about the level of general damages for human rights violations.
So, Michael, you mentioned this case earlier, but I wanted to ask about it again. Formally, it's called Canada and First Nations Child and Family Caring Society of Canada, but it came out of a human rights decision at the federal level, I believe, in 2016. And since then, it was went to the federal court on appeal, and the government of Canada lost. But I'm just wondering if you've been following along with that case, because I think for me, it's probably one of the more famous human rights cases I've heard of in my lifetime, or at least in my very short time in law school so far. So I'm wondering if you've been following along with it, and if you have been, kind of what are your thoughts on that? Is it sort of a revolutionary case in the human rights world, or is it just another day?
Well, I think it's revolutionary for a couple of reasons. And, certainly it's seen as revolutionary currently because of the value and the amount of money the government has been ordered to pay, in the billions. And I think it must be one of the, highest value human rights claims. But I think it's revolutionary in a couple of other ways. First of all, it was many, and the majority of human rights cases, I think, in Canada are individual claims. Individuals who say, I've been discriminated. Perhaps somebody who was fired because of a disability, or not hired, alleged that they weren't hired because of race, those sorts of things. Somebody, young woman who's fired because she tells her boss she's pregnant, those kinds of things. And, I don't want to say those aren't systemic, in the sense that many of them arise because of, assumptions and longstanding practices that have amounted to discrimination for many groups and individuals. But we don't see that many systemic cases, in the sense that a systemic discrimination is when there's a policy which is perhaps not on its face discriminatory, but it has the effect, the impact is to discriminate against a group based on their characteristic. And in the case we're talking about here, the argument was that, for children who live on reserves, indigenous children who live on reserves, essentially, the government underfunds, disproportionately underfunds health and education. So if you're a child in Canada and you live in Calgary or Edmonton, on average, there'll be X number of dollars that's spent by the government on your health and education. If you're a child who lives on a reserve, I think it was less than half that was spent on your health and education. And initially, what was really interesting about that case is initially a tribunal had dismissed the case because the tribunal said, the initial tribunal said, well, what's called the comparator group is not children who don't live on the reserve, But the tribunal said there's no discrimination because the government funds health and education services for all children who live on all reserves across Canada equally. So there's no discrimination. And that went up to the federal court and was overturned. So it was sent back to the tribunal, to a different tribunal, who then came up with the decision. It came, which is they found on the facts, on the evidence, that Indigenous children who live on the reserve are, the funding for their health and their education is less than half of what children elsewhere in Canada. So I think it was, quite groundbreaking in terms of the scope. It was, significant, and anytime you have a large case dealing with systemic discrimination, again, where this is government policy, and there's generally a presumption that government is allowed to set policy, right? And you can't, that you can't attack government policy. There's legislative supremacy, or the premise of legislative supremacy. So for all these reasons, I think is a really significant decision. The other thing I would say is, if people are really interested, there's a Cindy Blackstock, who was the leader of, really the thrust behind the case. She's written a fantastic article. I believe it is in the McGill Law Review, but I mean, if you Google Cindy Blackstock in the case, where she tells the whole story. And I think the story behind the case is also interesting, because she was surveilled by the police. Her social media was intercepted. They went after her and the organization, the government of Canada, to try to undermine her personally as she advanced the case. The other thing was using the force of the public and children and public efforts behind the case. I think it all makes it a really, really fascinating story, over and above, the significance of the legal decision.
My understanding of the case now is that the government of Canada has appealed, but it is, I believe, paused. Litigation has been paused while they try and work out a settlement. So I'm wondering, Jean, maybe just what are your thoughts on this case, and do you have any maybe predictions on where you see it going, and how it will impact human rights cases in the future?
Well, I think that we're going to all become very acutely aware of the government's role in systemically discriminating against Indigenous peoples, and how that didn't end with residential schools in 1996. The thing is, the complaints about the Child and Family Services funding in these cases started in 2006, 2007. And the government fought these concerns and complaints. And there's also health funding involved. So social service, what we call social service, the foster child system, child protection, but also health. The services available for children, they started complaining about this in 2007. And it's now in 2021 in September that a decision from the federal court upheld a finding. Well, first on the merits, the government never challenged the decision with respect to whether or not discrimination was happening. What they then challenged was the amount of compensation. And the amount of compensation awarded goes back to every single child who was in the system at the beginning of 2006, and every single child who passed through the system after that date. And it's a huge amount of money. And the question is whether or not it can be negotiated to be more reasonable for the government of Canada, because it's billions of dollars. And why should it be? At any rate, there have been political calls for the government to withdraw its appeal. So the federal court made a decision. That's a judicial review application. They made the decision. The appeal of that decision was filed in November. So it's very recent. And how long it will be paused, I think both sides will be using broader policy concerns in order to negotiate a settlement. But if it were to go to the Federal Court of Appeal, I don't think it's a done deal that it would be successful again. Right, and this may very well be a case that ends up in the Supreme Court of Canada. So there's the amount of compensation. That's one of the issues, $40,000 a pop. And then the second part of that decision is eligibility. Like, who is eligible for the $40,000 a pop? And I agree with Michael, absolutely. Go to read about what Cindy Blackstock has been through in the last 10 years over the processing of this case, because it hasn't been just the decision in 2016. The complaints started in 2007.
One of the things that was most striking to me, again, I hadn't had a chance to go too much into depth in the case. So before I actually read it, I was operating on the understanding that maybe there was some disagreement about equity. I always assumed that in this context, people, living far away would require more money for services. So I assumed it was something to do with that. But I listened to a podcast with Dr. Blackstock, and what shocked me the most was that, as Michael has highlighted, that it wasn't even formal equality here. So I really do hope they can, come to some sort of agreement on how to settle this, because it was quite a shock, quite frankly.
I'll stay tuned. You'll now, now that you've had a look at this case, you'll understand when you hear the headlines about withdraw the appeal or don't withdraw the appeal.
So our next question is regarding the ongoing project aimed at increasing Indigenous engagement with the Human Rights Commission. So if you could just describe it a little bit and maybe talk about how it's progressing.
The Human Rights Commission in Alberta has had a fairly long standing relationship with many Indigenous communities in Alberta, providing funding, grant funding, working with Indigenous communities to build local capacity, education training on human rights, and so forth. But full disclosure, last year, a report was commissioned by the British Columbia Human Rights Tribunal. The report's called Expanding Our Vision. And the BC Human Rights Tribunal had engaged Artis Walcom, who's now Justice Walcom of the BC Supreme Court. She was previously a lawyer, Indigenous lawyer in British Columbia, and she did just a really, really interesting study and report, essentially asking the question, why don't Indigenous people and communities use the human rights system? Why don't, certainly we know that Indigenous individuals and communities face discrimination in employment, in housing, in healthcare, government services, and so forth. And yet, given what we just know about the experience of Indigenous people in Canada, certainly an underrepresentation of Indigenous human rights complainants. And why is that? The answers, I think, are multidimensional. There are many factors. Anyway, so it's an excellent report, and I'd commend it to anyone who is interested in this topic, and I think we all should be if we're interested in reconciliation and how law and Indigenous relations. Anyway, we thought at the commission that it was important, in the context of the calls, the TRC and the calls the calls to action, and the MMIWG, the Inquiry into Missing and Murdered Indigenous Women and Girls, the calls for justice, of course, the discussions of the UNDRIP, United Nations Declaration on the Rights of Indigenous Peoples. Obviously the discussions about residential schools and the discovery of unmarked graves. It was time for us to take a much more active, take much more active steps to interrogate what does reconciliation mean, what does fairness, what does human rights mean for in respect of Indigenous people for the commission. And so we developed this strategy, which is on our website. Part of that is we brought together a group of an advisory circle of Indigenous leaders across the province from different communities, Métis, Indigenous, we don't have any Inuit, but 12 Indigenous leaders from across the province that will help guide us. We've hired an external consultant to look at the commission, and are there ways that our processes or our hiring practices, the way we do our work that may be perpetuating or complacent to ongoing colonization and discrimination. We feel that if we're going to say to Albertans and Alberta businesses and landlords and service providers, you need to look at yourselves, we need to look at ourselves. So these are the steps we're taking, and it's certainly a work in progress. But the next steps will be to look at our complaints process as we start inquiring into where the barriers are. We are looking to provide support and particular streams for Indigenous complainants. We've hired some Indigenous human rights officers to have do training across the commission, but also to provide specific supports and services for Indigenous communities. And the other thing that we'd like to do is to look at ways to have the capacity to address systemic complaints. I mentioned before, most of our complaints are individual complaints, but what about, are there issues? I mean, we know there are issues about the overrepresentation of Indigenous people in correctional facilities, or in terms of discrimination in terms of interaction with police, with the healthcare system. Are there systemic elements to that over and above individual interactions? And we have to ask ourselves at the commission, do we have the capacity to take on those cases? I mean, they are larger cases. They take resources in terms of policy, people who can work with statistics. It may take more legal resources, dedicated legal resources. So these are all the things that the strategy helps us, essentially it helps us to commit to, looking at the commission and asking these questions and then acting.
The Hearsay podcast is proud to present you with legal information, but it is important to remember that this is information and does not constitute legal advice. We are law students, not lawyers, and this podcast is purely for informational purposes. If you do require legal advice, please consult a lawyer. Thank you for listening to the Hearsay podcast. The Hearsay podcast is a joint project between CJSW and Pro Bono Students Canada, University of Calgary chapter. We would like to take this opportunity to thank CJSW for all of their support. If you would like to hear more podcasts like this, the Hearsay podcast can be found on Apple Music, Spotify, Google Podcasts, or wherever you get your podcasts. Until next time.